Welcome to the deep dive. Today, we're jumping into, a pretty high-stakes world. It's where corporate governance crashes into criminal law, especially when we talk about shareholder disputes here in Luxembourg. We're looking at what some people call the nuclear option in corporate battles. It's this dangerous legal toolkit that can completely change the game in any boardroom fight. Our goal today: to give you a kind of shortcut, a way to quickly grasp the specific criminal charges that get, weaponized in these situations. This deep dive is really for you. Maybe you're prepping for a big meeting or just trying to get up to speed on this tricky area, or, maybe you're just really curious about what happens when business disagreements go criminal.
Exactly. And we won't just be defining these powerful legal tools. We'll also dig into the strategy behind using them, the implications, and, importantly, the economic side of things. We want to pull all this together into practical insights so you understand not just what these offenses are, but really why they matter so much in the corporate sphere.
Okay, let's unpack this then. When things get heated in the boardroom, disagreements can spiral way beyond just civil lawsuits, right? They can actually land in criminal court. That's a huge shift.
It absolutely is. And, to help you navigate this complex area, we've boiled it down to 3 key takeaways. Think of these as your roadmap. So the first key takeaway is understanding the hierarchy of charges. The big insight here is that Luxembourg has a specific charge for company directors, but there are also broader charges that often come into play as alternatives.
Alternative?
Yeah, like powerful backup options. Grasping this hierarchy is, essential if you want to anticipate how a legal fight might play out. Okay, our second key takeaway really zooms in on the quest for intent. Honestly, this is where most of these cases are won or lost. Proving fraudulent intent, the courts call it mauvaise foi, or bad faith, is absolutely critical. It's a linchpin for the prosecution, and it's the main thing the defense tries to knock down. The whole legal fight often boils down to interpreting someone's actions to prove or disprove this specific state of mind. It's quite nuanced.
Intent seems like a slippery thing to prove.
It can be, definitely.
Oh.
Which leads us to the third key takeaway. The criminal complaint is a double-edged sword. Look, it's a hugely powerful tool for leverage, no doubt. But starting a criminal complaint, it's loaded with risk. You get the state's investigators involved, which is huge.
Delightful, yeah.
But you basically lose control. You hand it over to the authorities. Plus, it costs a lot, and it takes a long time. Often, its real strategic value isn't even about getting a conviction. It's more about forcing the other side to negotiate.
Right, using it as a threat almost.
Precisely. So, to really get these tools, we need to understand the basic rules of the game in Luxembourg criminal law first. These principles sort of draw the lines for any prosecution.
Exactly. And the bedrock principle is what's called the principle of legality. You might hear the Latin nulla poena sine lege, basically no penalty without a law. It's right there in the Constitution. It means criminal laws have to be read strictly. Judges can't stretch the meaning or apply them by analogy.
So even if something looks bad, even if it smells fishy, if it doesn't fit exactly into the wording of a specific law, it can't be criminally punished. That's a surprise for many. And that principle leads us straight into criminal liability, individuals and companies. Historically, you could only prosecute individuals. But back in 2010, there's a major change. They introduced criminal liability for legal entities. So now, companies themselves can face charges.
The company itself? Wow.
Yes. If an offense is committed in its name and in its interest by, say, its board or director, and this covers both the official director, the de jure one, and also the de facto director. That's the person who maybe doesn't have the title, but is effectively,
pulling the strings.
Pulling the strings, exactly. Making the key calls, doing the big deals. And what's really fascinating, I think, is that the company being liable doesn't let the individuals off the hook. Not at all. It creates this kind of dual track. Prosecutors can go after the company and the individual director at the same time.
Double trouble.
You could say that. And the penalties for the company, they're serious. We're talking hefty fines, potentially up to 750,000 euros. Plus, they could face special confiscation of assets, being banned from public contracts, or even in the most extreme cases, being shut down by the court judicial dissolution.
Okay, so that dual accountability really raises the stakes.
Massively. For everyone involved.
Right. This is where it gets really interesting, isn't it? Let's dig into the actual charges, the specific weapons in this arsenal. We need to look at the elements, how hard they are to prove, the penalties. Let's start with the one aimed right at the people in charge. Misuse of company assets, or abus de biens sociaux.
Yes, this is what lawyers call a délit de fonction, an offense tied to holding a specific position of power. The basic idea, it's laid out in Luxembourg's company law, is punishing directors who act in bad faith. They use the company's assets, its stuff, its money, or its credit.
Credit, like its reputation.
Exactly, its financial standing or reputation. They use it in a way they know is against the company's best interest. And they do it either for themselves, personally, or to help out another company they're tied to. The penalties can involve jail time, 1 to 5 years, and/or pretty significant fines.
Okay, so who can actually commit this? It's specifically directors.
It's aimed at directors, yes, both the officially appointed ones and those de facto directors we mentioned, the string pullers. But it's worth noting, even regular employees, if they're not directors, they can still be roped in as accomplices, if they knowingly help the director do something illegal.
Gotcha. And you said use of assets or credit. What does that actually cover? How broad is it?
Oh, it's interpreted incredibly broadly by the courts here. Assets isn't just cash flow. It's anything the company owns that has value. Think company cars used for family holidays, using the office for private party, intellectual property, even customer lists if they're valuable.
Wow.
And use of credit is even wider. It could be any action that puts the company's financial reputation on the line, like maybe using the company's good name to back some dodgy investment scheme, even if no actual company money was spent directly at that moment.
Okay, that's broad. But you mentioned the motive, acting against the company's interest. That sounds like the really tricky part.
It often is. It's the most fought-over element, usually. There's a two-part test here. First, the action itself must be contrary to the company's interest. This basically means exposing the company to some abnormal financial risk without any real business justification. The classic example is billing your personal holidays or dinners to the company card.
Right.
And for groups of companies, there's this doctrine, the Rosenblum doctrine, that the courts use. It says, okay, you can give financial help to a related company, but only if it makes sense as part of an overall group strategy, and there's some kind of benefit flowing back. And crucially, it doesn't put the company giving the money at serious risk.
So it has to be a legitimate business move, not just shuffling money around.
Precisely. And the second part of the motive test is that the director's action must be for personal gain or to favor another enterprise. This gets back to that bad faith idea. They have to be seeking some personal advantage, could be money, like an inflated salary, but it could also be non-financial, like helping out a relative's business. Or the aim could be to benefit another company they have an interest in. That's where the intent, the mauvaise foi, really comes under the microscope.
Yeah, that focus on intent and just the practical challenge of proving it, that seems absolutely central. I know we've seen cases, you can find them on justice.public.eu, where Luxembourg courts have really gone through the paperwork with a fine-tooth comb. There was that famous one about a Lamborghini lease, wasn't there? Trying to figure out if it was genuinely for business.
Or just personal enjoyment, exactly.
And another case where because family members were involved, the whole thing was considered sort of hidden.
Yeah.
That actually pushed back the start date for the statute of limitations, the 5-year clock. It shows how the specific facts can really change the legal timeline.
That's a great point. And it ties into the evidentiary requirements. In theory, the prosecutor has the burden of proof. But in practice, what we often see in jurisprudence is a kind of shift. If there are suspicious transactions, the courts often expect the director to come up with a believable explanation for why company money was used that way.
So if they can't explain it,
If they can't give a good reason, that silence or weak explanation can be seen as pretty strong evidence against them, suggesting misappropriation. The whole case usually hinges on digging through that paper trail board meeting minutes, bank statements, expense reports, emails.
meticulous work.
Very. Now, what happens if the specific elements for abus de biens sociaux, for misuse of company assets, aren't quite there? Maybe the contrary to interest part is fuzzy, or proving the personal gain is tough. Well, prosecutors often then pivot to a broader charge, breach of trust or abus de confiance. This one's defined in the penal code, not company law. It basically targets anyone who fraudulently messes with assets, money, goods, even documents that were entrusted to them. The key word is entrusted. They were supposed to return them or use them for a specific purpose, and they didn't.
Okay, entrusted. So what are the key pieces, the constituent elements for that?
Right, 3 main things. First, and this is the absolute cornerstone, there has to be a pre-existing agreement. Proof of some prior contract, like a mandate, maybe a loan for use, a deposit agreement, something showing the asset was handed over temporarily for possession, not ownership. Without that agreement, you can't have breach of trust.
No agreement, no case.
Pretty much. Second, there needs to be an act of misappropriation, a détournement. The person accused must have done something with the asset that's incompatible with the real owner's rights. Maybe they sold something they were just supposed to hold, or destroyed it, or used it for something totally unauthorized. And third, again, we come back to fraudulent intent. It's a dual special here. The accused must have knowingly, willfully acted like they owned the thing, fully aware that doing so would harm the actual owner. Luxembourg case law hammers this home again and again. Fraudulent intent is an essential element.
So this helps explain that hierarchy of charges you mentioned earlier.
Exactly. Abus de biens sociaux was created precisely because the older abus de confiance charge didn't quite fit all the bad things directors might do. For example, think about an employee, not a director, using the company credit card for a shopping spree. That's abus de confiance, breach of trust, because the card was entrusted to them for business use. It's not abus de biens sociaux because they aren't a director. Or maybe a director did do something questionable, but proving it was strictly contrary to the corporate interest for ABS is difficult. The prosecutor might then go for abus de confiance because it might be easier to prove they simply misused entrusted funds under an agreement.
Makes sense. And the penalties?
For breach of trust, it can be imprisonment from 1 month up to 5 years and a fine as well. Okay, so that brings us to the third main weapon, fraud or escroquerie. This one shifts the focus. It's less about misusing something entrusted to you and more about active deception to get something from someone else. The Penal Code defines it as tricking someone into giving up funds, assets, or even canceling a debt, causing them harm by using specific deceptive tactics.
Deceptive tactics. So what are the constituent elements here? Is just telling a lie enough?
No, crucially, a simple lie generally isn't enough for fraud in Luxembourg. You need something more elaborate, what the law calls maneuvers fraudulosus. It requires some kind of overt act, a scheme, something staged, a mise en scène to back up the lie and make it believable.
Like what? What kind of schemes?
Well, it could be using a fake name or pretending to have a certain qualification or position you don't have. It might involve bringing in a third person to vouch for you falsely to add credibility. Or, very commonly in business disputes, it involves producing fake documents, things like bogus invoices, doctored financial statements, forged contracts.
Okay, so you need the scheme. What else?
The scheme has to work. The result must be that the victim is actually persuaded by the deception to hand over something valuable, money, property, whatever. And of course, there's intent. The person doing it must have had the specific goal of deceiving the victim and unlawfully getting something for themselves or someone else.
Now, I often hear the term organized fraud thrown around in these kinds of corporate disputes. How does that fit in? Is it a separate crime?
That's a really important clarification. Unlike some other countries, like France perhaps, Luxembourg law doesn't actually have a single specific crime formally called organized fraud, or escroquerie en bande organisée.
Oh, interesting.
Yes. So when you hear that term, what prosecutors are usually doing is taking the basic charge of fraud, escroquerie, and combining it with an aggravating circumstance. Specifically, the circumstance that the fraud was committed as part of a criminal association or organization, an association de malfaiteurs or organisation criminelle.
So it makes the fraud charge much more serious.
Exactly. But it also makes it significantly harder to prove. The prosecution doesn't just have to prove the fraud itself, they also have to prove the existence of this structured, coordinated group working together with a shared criminal goal.
Which seems quite relevant in shareholder fights where maybe multiple people are involved.
Highly relevant. You might have a director, maybe an accountant, perhaps an outside consultant, all allegedly working together. If prosecutors can prove that organized element, the penalties jump significantly. Simple fraud might get you, say, 1 month to 5 years and a fine, but add the organized crime element, and it can become a much more serious felony, a crime, with potentially much harsher sentences.
Okay, so we've dissected the charges themselves. But what does this all actually mean for someone caught up in one of these disputes? Understanding the law is one thing, but using it strategically is another. Let's talk about actually initiating a criminal complaint. The procedure, the paperwork.
Right. If you're the victim, maybe the company itself or an aggrieved shareholder, you generally have 3 main ways to kick things off. The first is the simplest. A simple complaint. A plainte simple. You file it with the police or directly with the public prosecutor, the procureur d'etat. It's straightforward, but the prosecutor has discretion. They operate under this principle of opportunité de poursuite, meaning they can decide whether or not to proceed. They might just close the file, classer sans suite.
So no guarantee of action there.
None at all. That's why the second option is often much more powerful. A complaint with civil party attachment, plainte avec constitution de partie civile. This one you file directly with an investigating judge, a juge d'instruction.
And that changes things.
Big time. Filing this way essentially forces the judge to open a formal judicial investigation, an instruction. It bypasses the prosecutor's discretion. Plus, you, the complainant, become a formal party to the case. You get rights, like accessing the case file and asking the judge to take specific investigative steps.
Okay, that sounds much stronger. Is there a third way?
Yes, in some situations, if your simple complaint gets dismissed, you might have the option of a direct summons, a citation direct. This lets you haul the accused directly before the criminal court yourself. It's less common, but it's another potential route. But this is crucial. Whichever route you take, you can't just show up with vague accusations. Your complaint needs to be backed by a really solid file, a strong dossier of evidence.
Evidence like what, specifically?
Well, it depends on the charge. For misuse of company assets, ABS, you'll need things like shareholder agreements, board minutes showing decisions, definitely forensic accounting reports tracing the money, proof of personal expenses paid by the company. For breach of trust, abus de confiance, that foundational agreement we talked about, the contract showing entrustment, is absolutely key. And for fraud, escroquerie, you need to gather all the communications, the emails, the letters, and especially those falsified documents that made up the maneuvers fraudulences, the deceptive scheme.
Right. And you mentioned earlier that these things take time. What kind of timeline are we actually looking at? It's not quick, is it?
Not even close.
Yeah.
That 2023 ministerial response you mentioned really highlighted it. The average time for a judicial case to wrap up in Luxembourg, 619 days.
Wow, that's nearly 2 years, on average.
Exactly, and that's just the average. It involved the whole process. Yeah. The investigation phase, then the prosecutor deciding whether to actually prosecute, then the trial in the first court.
And
then potentially appeals. There's a 40-day window to appeal the first judgment. And after the appeal court, there could even be a final appeal on points of law to the Court of Cassation. So, yeah, it's a marathon, definitely not a sprint.
Which really brings us to the strategic side, doesn't it? The art of legal negotiation and how the criminal complaint is used as leverage.
Absolutely. This is often the core reason for filing in these shareholder disputes. The primary strategic goal frequently isn't about getting that final guilty verdict years down the line. It's about changing the negotiation dynamics right now.
How does it do that?
Well, just the threat or the actual filing of a criminal complaint puts enormous personal pressure on the directors involved. Suddenly, they're facing the possibility of prison, a criminal record that follows them forever, huge damage to their reputation. It gets very personal very quickly.
And it unlocks the state's powers.
Yes, that's the other big lever. It brings in the state's investigators with powers like searches, seizing documents and computers, hauling people in for questioning, things you just can't do in a purely civil case. They might dig up evidence you'd never find otherwise. Plus, there's another layer. Since misuse of company assets is a predicate offense for money laundering, filing a complaint can trigger red flags with financial regulators, with the banks, adding even more pressure from different angles.
Okay, but you mentioned this paradox earlier. If a shareholder files, say, for misuse of company assets and the company eventually gets damages paid back, the shareholder doesn't get that money directly, right? It goes back to the company.
That's generally how Luxembourg jurisprudence sees it, yes. The direct harm is considered to be to the company's assets, not the shareholder's personal wealth directly, even though their shares might lose value. So any damages recovered go back into the company coffers.
So if the individual shareholder isn't the one getting the payout, how does this whole process become such a powerful hammer in negotiations? Why would they go through all this?
That's the million-dollar question, isn't it? It's precisely because the goal often isn't the financial recovery for the company. The criminal complaint acts as this incredibly strong lever to force a different kind of outcome, usually outside of court. The aim is often to push the other side towards a settlement. Maybe they agree to buy out the complaining shareholder's shares at a good price. Or maybe the accused director agrees to resign quietly. Or perhaps it leads to a global settlement wrapping up all the disagreements between the parties. The criminal case becomes the tool, the hammer, if you like, that forces the other side to sit down and negotiate seriously to avoid those potentially devastating personal and professional consequences.
That sounds incredibly effective strategically, but also, as you said, risky. It really is that double-edged sword, isn't it?
It absolutely is. Because once you file that complaint, especially the one with the investigating judge, you lose a lot of control. The prosecutor takes over. It's their case now. And you're racking up significant legal costs the whole time. And there's always that lurking risk. What if your complaint is ultimately thrown out? What if the court finds it was baseless, filed in bad faith just to cause trouble?
Then you could face a counterclaim.
Exactly. A counterclaim for malicious prosecution, denunciation, calumnies. So yes, it's a very high-stakes, high-risk gamble, powerful, but dangerous.
Okay, this sounds like a strategy that requires deep pockets too. Let's talk about the economic realities, the costs and the pricing involved in wielding this kind of legal weapon.
Right. While the actual court filing fees in Luxembourg might be relatively low, the other costs can really add up. If you file that complaint with an investigating judge, you typically have to deposit something called a consignation. It's basically a security bond, could be a few thousand euros, could be tens of thousands to cover potential procedural costs down the line.
But that's not the main cost, is it?
Usually not. The really significant costs often come from the experts you need to hire, especially forensic accountants. Their detailed reports, digging through complex financial records to prove wrongdoing, are often absolutely essential, particularly for misuse of company assets. And their expertise doesn't come cheap.
And then there are the lawyers' fees themselves. How does legal pricing work in Luxembourg for this kind of work? Is it standardized?
No. There's no official regulated price list or tariff for lawyers' fees here. It's all based on an agreement between the lawyer and the client. The most common model you'll see is the hourly rate, the taux horaire. This can vary quite a bit, maybe starting around 250 euros an hour, going up to over 350 euros, sometimes more, depending on how senior the lawyer is, the reputation of the firm, and so on.
Are there other models? Fixed fees?
Yes, sometimes flat or fixed fees. Forfait might be agreed for specific, predictable tasks. And you can also have a success fee, an honoraire de résultat. That's an extra fee paid on top if you get a positive outcome. But, and this is a strict rule from the bar, you cannot have a pure contingency fee arrangement, where the lawyer only gets paid if they win. That's absolutely forbidden in Luxembourg.
Good to know. So the final bill depends on?
It really depends on how complex the case is, how much paperwork there is to go through, how long it all takes, and obviously the experience level of the legal team working on it. And don't forget, all legal fees are subject to VAT, currently at 17%.
Okay, so looking forward a bit. Are there any trends? What's happening in this area? And what really makes this criminal route so uniquely powerful despite all the costs and risks?
Well, looking at recent legislation, there definitely seems to be a trend towards modernizing and perhaps toughening up on white-collar crime in Luxembourg. For instance, a law in December 2021 brought in electronic case files, which streamlines things, and it also expanded the court's reach, their territorial jurisdiction. And even more recently, that law from August 2023 extended the misuse of company assets offense beyond just commercial companies. Now it also applies to nonprofit associations and foundations. That broadens the net quite significantly.
So the scope is widening.
It appears so. And there are ongoing legislative projects, too, which suggest a continuous effort to sharpen the tools prosecutors have for these kinds of complex financial cases. So if we try to connect all this back to the big picture, despite the risks, the costs, the long timelines we've talked about, using the criminal law route in a corporate fight remains this uniquely formidable weapon. Why? I think it boils down to three things that civil lawsuits often just can't achieve as effectively. First, leverage. Pure and simple. It puts immense personal, almost existential pressure on your opponent. The risk of jail, a criminal record. That's far beyond typical civil penalties.
Right, the personal stakes.
Second, evidence. It unlocks the state's coercive investigative powers. Searches, seizures, interrogations. They can dig much deeper into financial records and communications than you typically can through civil discovery processes. And third, finality. A criminal conviction can have truly irreversible consequences. For example, someone convicted might be legally banned from ever serving as a director again. That could permanently break a shareholder deadlock in a way a civil judgment might not.
Leverage, evidence, finality.
Exactly. That potent mix, the personal pressure, the deep investigation, the potential for a permanent resolution makes the criminal arsenal the most powerful and frankly the most feared weapon in a Luxembourg corporate conflict.
Okay, let's quickly wrap up with those three key takeaways again, just to make sure they stick. First, remember that hierarchy of charges. You've got the specialized abus de biens sociaux for directors, but also the broader, versatile options like abus de confiance and escroquerie in the toolkit.
Second, it all hinges on intent. Proving or disproving that fraudulent intent, that mauvaise foi, is central to both prosecuting and defending these cases.
And third, launching a criminal complaint is a serious strategic move. High risk, potentially high reward, often used more to force a negotiation than to see it through to a final court verdict. It's that double-edged sword.
Which, I think leaves us with a really interesting question for you to think about. In today's increasingly complex business and regulatory world, how do you actually balance the undeniable strategic power of these criminal law tools against the very real, very significant personal and professional risks involved in using them?
That is a powerful thought to consider. Thank you so much for joining us on this deep dive into the very intense intersection of corporate governance and criminal law in Luxembourg. We hope you found it insightful.